there's a section in there that says if the company doesn't do what they're supposed to do, you can bring it back to the CCMA, and the CCMA can make that an award, and that award can then become enforceable, and you can go to the sheriff. Let's just talk about the other side, if you agree with the process. If you agree with the process, the commissioner then will complete an agreement between the parties.
Okay, a settlement agreement.
We call that a settlement agreement.
Lovely.
That's normally a template that the CCMA has, or the bargaining council, where we write in what is the agreement name, surname, what were you earning, and what would be the amount over the period that you've agreed. If it's 3 or 4 or 5 or 6 months, that is what is the kind of thing that will be taken.
Okay.
That agreement is binding on the parties.
Okay.
And there's a section in there that says if the company doesn't do what they're supposed to do, you can bring it back to the CCMA, and the CCMA can make that an award, and that award can then become enforceable, and you can go to the sheriff and attach the furniture of the...
Lovely.
What you call. If the matter is not resolved, we then get to the next stage, which is called the arbitration stage. Now, the arbitration stage happens depending on a number of things. So for example, if you have had a process which is called the CONUP.
Yes.
Now, the CONUP process is a very interesting process introduced in 2002. And it brings two processes together at the same time.
Okay.
It's a conciliation process together with an arbitration process.
Okay.
And there are, hopefully, this process will go longer so that we can talk about some of the other kinds of things, because there's a lot of things that need to be explained with regard to the CONUP process, because it's a process on its own and how it needs to be dealt with.
Okay.
But to all intents and purposes, if you are at the arbitration process, it doesn't happen automatically.
Okay.
In terms of the law, it says that there are two things that happen. Firstly, once you've had that conciliation process with the commissioner, and the commissioner finds that the matter is not resolved, the commissioner will then say to you that I'm going to issue you with a outcome certificate.
Right.
Now, this outcome certificate says, I've heard Ronnie, I've heard Johnny, who's the company. They were before me. We couldn't settle the matter. From this date onwards, the matter between the two of them is unresolved, and it can move to the next process. And the applicant, who's the employee, has got 90 days within which to go for the matter to go to the next level.
To arbitration.
Okay. Which means it's a completion of what we call a 713 form.
Right. So they leave that room with a certificate of non-resolution.
Yes.
And then they go to a room where they can apply for an arbitration proceeding.
Exactly.
So they can either do it online once again,
Exactly.
713 form,
Exactly.
or they can do it at the CCMA on the day
Exactly.
when
They go back. They can even go back to the same person.
They
sometimes.
can go back to the office downstairs
where
to fill out the next form
where the form
for the
is
next process.
going to be completed.
Lovely.
And in that form, it asks again the same details: who you are, who's the other side, etc., etc. Matter is unresolved. Matter needs to be set down for
Cool.
arbitration.
Then I get a date from the CCMA, the employer gets a date from the CCMA, and we are in that room.
You're under arbitration.
Most likely with a different commissioner who will be then.
And you can also be with the same commissioner.
Oh, you can also be with the same commissioner.
Because
That's
provision is made in terms of the law that the same commissioner can also arbitrate your matter.
So
of course, if you've been unhappy with the commissioner at conciliation, the same commissioner, because of comments that they've made, you're entitled to approach the CCMA and ask for that commissioner to be replaced. But that's another process that takes.
So we get in there, and now the commissioner becomes the arbitrator. So now it's more formal, right?
It's very, very formal.
Now it's quite formal.
Very, very formal.
And the law requires certain things to be done.
Happen.
Right?
Yes.
Okay. So what happens in that formal process? What do the parties now need to prepare in order to go into a smooth arbitration?
Yeah. The formal process is the presentation of your case through evidence.
Okay.
That's called arbitration.
All right.
So it means that you bring each and every bit of information that you believe the commissioner should know, And there's a requirement of the commissioner to consider all the evidence. And under those circumstances, the commissioner will then kick the process off.
Okay.
So you as the applicant must bring your payslip, you must bring your dismissal form, you must bring letters that are between yourself and the company. I've seen in some of the cases people brought letters that are even yellow in color of all the things that had happened, and in a brown paper packet or brown envelope. And on the other side, the company will bring all their evidence. Now, it's important that we need to understand the arbitration process. The commissioner makes a decision on what happens at the arbitration process.
Okay.
Not what happened at the hearing, disciplinary hearing of the applicant.
Okay.
So the commissioner's result or his outcome will be from what you have placed before that commissioner. So if you did something, put something at your disciplinary hearing and you don't place it in front of this commissioner is not going to consider it.
He's not going to know what
He's
happened.
not going to know what happened at the what you call it. So you've got to bring everything in front of this commissioner.
So everything is, it can be recordings that you have, any paperwork that
photographs,
you have, photographs, emails,
and
witnesses. That's
witnesses
important,
that
right?
saw these things happening.
This thing happen.
You name it, you bring it.
Okay.
So that the commissioner is aware of it.
As long as it actually benefits your case.
And it must be relevant to the process.
Correct. That's also important. It's got to
very,
be
very important.
So the difference here is that in conciliation, the power sits with the two parties.
Exactly.
They make those decisions.
Exactly.
And in arbitration, now the power shifts
Yeah.
to an independent third party,
Yeah.
being an arbitrator.
Yeah.
You bring your evidence, the other party brings their evidence, you present it according to the processes that the arbitrator will tell you who starts, who starts,
yes.
right?
Yeah.
Now, when it comes to those kind of processes, because we're saying it's a little bit more formal. In fact, it's pretty formal in that
very,
regard.
very formal.
Are lawyers allowed to be in that room with the parties, the applicant and the respondent, the employer and employee?
Yeah. Now, unfortunately, lawyers are not allowed everywhere.
Sad.
There are certain circumstances, but we need to take a step back because we need to understand it. The intention for having the CCMA was to give parties an opportunity to present their cases.
Okay, themselves. Okay.
But the legal process is what it is, and it allows for people to be represented. CCMA has got a rule, which is Rule 25, that speaks about who can represent and who can't represent.
Okay.
In the first part of that rule, it says that anyone who is a representative from the union or a representative from an employer's organization or the parties themselves are entitled to represent themselves at conciliation.
Okay.
No legal representation is allowed at conciliation.
Because it's more informal.
And you've got the commissioner plays the role there of the facilitator, and you don't need somebody else to come and tell you what the issues. The parties themselves know the issues better.
They were there.
And yes, because lawyers represent parties, and all they tell you is what the parties told them.
Correct. Okay.
At conciliation, the party tells you what happened to me.
Okay.
And not what I heard somebody else say.
Okay.
When we come to arbitration, it takes us to the second part of Rule 25. And depending on what your matter is that is before the commissioner, it will say whether or not legal representation should be allowed.
Okay.
So if your matter is for misconduct, remember the one that we spoke about earlier, when we
Correct.
spoke about breaking of the rules?
Yes.
Or it's a matter of what we call incapacity. Now, this is the first time that we introduced this concept.
Right.
And so we just need to explain that quickly. Incapacity can stand on two legs. You can either be medically incapacitated
Okay.
In other words, I'm suffering from cancer.
Yeah.
I can't do the work that I'm supposed to do anymore. And so under those circumstances, when you look at my work, I'm not attending regularly, etc., etc. And then I need medical certificates and those kind of things to say that, look, Ronnie can't work any longer. He's really had enough.
Right.
The sickness is really getting to him.
Okay.
That's the one.
Right.
The second one is what we call poor work performance.
Okay.
Now, that's also another matter where the company gives you certain targets to meet. And normally it applies very well when it comes to salespeople, or often applies to salespeople because they are the ones that need to meet certain targets with regard to their workplace. And so when they fail in those targets, the company is entitled to then bring them to the CCMA. So if your matter involves that, then under those circumstances, you are not automatically entitled to legal representation.
Okay.
Then there are others that will not apply directly to employees, which is Section 69, Section 73A, Section 198A. The ones that I've mentioned has to deal with compliances by the companies with regard to Labor Relations Act and Basic Conditions of Employment Act. Because normally what you would have done with regard to those, you would have taken them to the Labor Department to be able to deal with it. But the CCMA now has the capacity to be able to deal with that.
Okay.
And so under those circumstances, if your matter involves any of those, the commissioner, together with the parties, must agree for legal representation to be allowed. Okay. And the commissioner has got certain criteria that he follows in determining whether or not legal representation should be allowed. He looks at, for example, is this a difficult matter? Are there any legal issues that's going to be involved in this matter? Is the matter in the public interest?
Yeah.
You know? And what is the prejudice if I don't allow legal representation under those circumstances? And so what you will then have to do at the arbitration hearing, you'll have to put your hand up and say, Mr. Commissioner, or Madam Commissioner, or Master Commissioner, I am here to represent the parties, but we know that it's one of those that doesn't automatically allow me to sit in and make the determination. And so under those circumstances, I want to bring what we call an application. And then the person who brings the application, it can either be the employee's legal representative or the employee's legal representative, will then prove to the commissioner, based on those factors that I've said, complex matter, lots of legalities in it, in the public interest, certain prejudice, will then listen to those and then decide. And this is an important part where this decision is made. Can this party continue on their own to manage the process? That they would be able to present a proper case to you as a commissioner, so that they can bring across what resulted in the dismissal at the end of the day.
So
and why they're unhappy about.
What circumstances does the arbitrator then look at about the person's ability to be able to bring the matter forward?
Well, what is the knowledge of the person with regard to the process?
Okay.
So, for example, if I'm dealing with a domestic workers case, surely domestic worker will, unless of course she's a highly qualified domestic worker who decides that she wants to deal with, she wants to work because she hasn't got work elsewhere. I mean, that's very seldom the case.
Correct.
But also the person who provides the services for the domestic worker.
Okay.
Remember, they're not normally lawyers. They don't know these processes. Okay. So that's one of the things that I would look at. But also in the ordinary workplace. We are now fortunate in that we have legal insurances that are around.
Okay, that you can bring
that allows for people to bring lawyers to these processes. So they appear quite often before us.
All right. Tell me, in a situation where, for obvious reasons, employees don't necessarily afford attorneys, and the employer definitely most of the time can afford an attorney, right? And then the attorneys or for the employer is there. They make the application in front of the arbitrator. I want to represent my client. These are the reasons. Please, can you allow it?
Yeah.
Now, the likelihood of the employee now at that point in time having a lesser of a chance to win, because now here he is, can't afford an attorney. He's going against this employer who can afford attorneys. So now there's now two heavyweights in the room against me, the employee.
Yeah.
How do we balance out those dynamics?
Yeah. Our role as commissioners is to bring a level playing field in the process.
Okay.
And so the law actually instructs me as a commissioner that where somebody is before me who has no knowledge of the law, that my role becomes a more inquisitive role.
Okay.
Rather than a sit-back role where there are attorneys in the room and say, oh, well, you guys fight it out. When you've got the winner, come and tell me so that I can say what is the result with regard to that.
Yeah.
But where there's no such thing, you also have then an opportunity as a commissioner to guide the person who is not well au fait with the process.
Okay.
As to this is what needs to happen. In fact, it's of utmost importance that when we are dealing with a person who has got no knowledge of the process, the law requires of me, this is the case law, that I must explain the process to the parties in its minutest of detail.
Okay.
So that they understand. And when I am in the process, and I see that the one party has not done something that they're supposed to have done, I should say to the party that, look, if you don't ask questions on what they are saying you have done wrong, I just accept that as correct. So you better make sure that you ask questions so that, and sometimes it's a catch-22 situation, because a person asks questions because I said you must ask questions, but really they don't have real questions on when they said, we found you at the gate with a pin of red paint. So, okay, I was found at the gate with a tin of red paint. What is the question that I asked? Was it a full turn or was it a half turn? Did it have a label on or what?
Yes.
Now we start getting into the technicalities. And it's important to understand that as commissioners, we don't operate the same as judges do when they sit in a criminal court. We look at the probabilities and we say at the end, when I look at the version that is being presented, which of the versions is the most probable of the two versions? Okay. And then I make a decision. So you don't have to show that's exactly what it was. That's the corner that it was in. That is what the thing looked like and all those kind of things. The fact that they have charged you for something, they would have explained what resulted in you being charged. Okay. And based on that, you then have to counter that by saying that, no, what they're saying happened really did not happen. So it's really what it turns on. Yeah. And a lot of people make the mistake and think that we've got to show everything to the commissioner, where it was, what it was, how it was. No. You just have to say to me, well, when they say that I was in the red room, there is no red room. Yeah. So I couldn't have been there. That's the kind of thing that we're talking about. Okay. So you don't want them to now go and show that this is where the red room is, this is the corner that it's in. All that we need then is the company to come back and say, well, let's ask Johnny. Johnny, is there a red room? Yes, there is a red room. I'm the operator of the red room. I am the one that got the key to the red room. Here are pictures of the red room. Okay. All right. That's all we have for this segment. Thank you for tuning in to Mamolao. Please don't forget to subscribe and click on the notification bell for more of this educational legal content. Make sure that you comment, guys. I want to hear from you. And also ask questions because I want to hear those too.